Got it? All right, here we go. So gave you the handout. Recent headlines. Realtors agree to axe 6% commissions. The NAR lawsuit will change real estate. Powerful realtor group agrees to slash commissions. Thanks to NAR settlement, real estate is in the Wild West. 6% commission on buying or selling a home is gone. It's the end of the world as we know it. No. Yeah, they're right there. And I have some in my briefcase if you want more. The interesting part is that in reality, two things changed. Just two things changed. And that is that you are not, or NAR will not require or allow a contributing or a commission for buyer's agents to be placed on MLS. So no longer are you going to be able to put those types of commission offerings on MLS. The other thing is that NAR, if you're a NAR member, is going to require that if you are a buyer's agent that you have a agreement with the buyer, a written agreement with the buyer. Those are the two main things. Other than that, not much has changed. What's the reality of all of this? Well, the reality of all of this is there was a case brought in a federal court in Missouri. And in Missouri, the decision was made by a jury that NAR had violated the rights of sellers by forcing sellers to pay a buyer's agency fee. And therefore, they assessed damages of about $1.4 billion. There were over 10,000 plaintiffs in this class action lawsuit. Keller Williams and others were sued as well. They settled out of court. And finally, and this judgment was granted last October, NAR, realizing that this kind of a judgment would bankrupt it and that it didn't really think it was going to win on appeal, decided in March to agree to a settlement. And the settlement basically said those things. They agreed that a new MLS rule prohibiting offers of compensation on MLS. This would mean that the offers of compensation could no longer be communicated via MLS. And they also agreed for a new rule requiring MLS participants working with buyers to enter into a written representation agreement with the buyers before the buyer tours a home and shows the services they provide and their value. Those are the two things they agreed to. Now, is it binding as law? No. This is NAR agreeing that NAR members will follow this rule. And since NAR owns MLS, it will follow the rule for MLS. This is not something that is binding as law on anybody other than those people that were involved in the lawsuit. Remember that a judgment in a district court, federal district court, is a judgment with respect to those people that are there. If it went on appeal and the appeals court made a decision that said certain things like this, then that would be judgment for the entire country. That didn't happen. They avoided that by not going forward with the appeal and having appeals court actually hear and decide on the case. The big fear that everyone has is the Department of Justice. The Department of Justice has for years gone after NAR and the idea that a brokerage commission, which is substantially the same throughout the entire country, is considered either a monopoly or it's price fixing. And they still believe that. And now that they've seen blood in the water, they're going to start pushing a little further than they ever have before. So, is the commission structure going to change? No, not now. There's nothing out there that's going to change the commission structure. There's nothing that NAR has agreed to that says that the commission structure is going to change. They're not telling you what to charge for a commission. All they're saying is that you can't put that commission split on MLS any longer. Now, it doesn't speak as to splits with other seller agents. So let's remember where we were 20 years ago. We didn't have buyer's agents. Everybody was a seller's agent. And when buyer's agency first started, they were pariahs. NAR hated them. Everybody hated them. People wouldn't let them into the house. And a buyer's agent was paid by the buyer. So they were getting paid $500, $1,000, something like that. They couldn't guarantee they were getting a percentage. But as buyer's agents became more popular, everybody saw the writing on the wall, and NAR embraced them and said, look, if you're a NAR member and you have an MLS listing, and a buyer brings you a ready, willing, and able buyer, you have to pay them the commission as if they were the seller's agent as well. So there was no distinction anymore in terms of contributing, or a procuring agent being paid or not being paid based on whether they represent the buyer or the seller. So where does this lead us today? Well, it leads us to a few things. First of all, none of this talks about whether or not you can place a commission fee split on your own website. That's the interesting thing. That was not discussed in the case. So, can you do that? There's nothing that says you can't do that. You can show cooperative compensation in that fashion unless there is some kind of a case that's going to come down and say no. Do you have to have a written buyer agreement for a buyer agency? A Massachusetts case was just decided recently that said no. You don't need a written agreement in Massachusetts for a buyer's agency to be paid a commission. And that was the case of Huang versus Remax Leading Edge. So all of the things that we have in the NAR settlement aren't necessarily applying to individual agencies. Now, yes?
Can you refer to seller offering a concession in firm remarks in MLS, anything like that?
Seller offering a concession?
Yeah, in other words, can I say sellers willing to pay buyer concessions of up to 2.5% or anything like that?
Again, if it's on MLS, no. If it's on your own website, there's nothing that says you can't.
So you can't refer in any way to the seller compensating or offering concessions?
Not on MLS. Now, again, this doesn't come to fruition until July. The court hasn't accepted the settlement yet, and the Department of Justice could still come in and push for something different, but about somewhere around mid-July is when they expect that the court will finally make a decision, and NAR isn't forcing any of this until that time, but I think they have pretty much pushed everybody to say, don't put your commission structure on MLS any longer. But yeah, that's basically where it's at. And what the court was trying to get them to do, what the Department of Justice was trying to get them to do, is not force a seller to pay a buyer's agent. Now, to some degree, that makes some sense. Why is the seller going to pay the agent who's working against him and trying to get a better price for the buyer? And that was the argument made in court, and the jury accepted that argument. So we're not going to argue about that. The fact is, where does it stand today? So, again, it's interesting. The president of NAR was quoted as saying, "The way we operate our business is going to change, either embrace or adapt, or it's going to be forced down our throats." And that's why they entered into the decision. So that's where it's going to be for them. Fannie Mae and Freddie Mac. So one of the things people have talked about is, okay, you come up with a buyer and you say, all right, is my buyer, and my commission is 2.5%, and I want that included as a seller concession in the purchase and sale agreement. Now, we're in a seller's market, so the likelihood of that is a little less than if we were in a buyer's market and the sellers were desperate to get a buyer. But Fannie Mae and Freddie Mac came out yesterday and said that if you do that and you put it in the purchase and sale agreement, they will not count that toward seller concessions, meaning there's a limit to which Fannie and Freddie will allow seller concessions for, seller closing cost payments and things of that nature. This will not be included in that calculation if it's stipulated in the purchase and sale agreement that seller is paying for buyer's agent's commission. Yep.
There's nothing that stops me as a listing agent from charging 5%, and then, as per usual, I cut that check to the buyer agent post-close.
Right.
Correct.
As far as I can see, there's no limitation to that.
So my commission is then 5%?
You can contribute anything you want to the buyer.
Right.
There's nothing saying that you can't pay a buyer's agent. What they're saying is you can't put it in MLS.
Right, but if I take the total, per usual,
Yeah.
and I cut a check, that's still possible?
Yeah.
No
Yeah.
reservation?
Yeah, absolutely. Absolutely. And what I would do is I would put it into the purchase and sale agreement maybe.
Can you list the buyer's agent in the purchase and sale, or do you recommend not and we just handle it separate?
You can do it either way. You can do it either way. You can put it in as a seller concession that'll be paid by the broker, or you can just do it as you collect a commission,
But I
and
thought
then you
said
cut a
let's
check.
Put it in as a seller concession.
Yeah, and or you can get the check, cut it, and give him a 1099 for the split that you're giving him.
Right. Right.
Yeah.
Which is what
And then it'll be known that your agency does that, and that'll get out there. So that you don't have to list it as that's what you do anymore. Everybody's going to know that's what you do.
But there's not a problem with it.
There's not a problem with it. They're trying to get away from it, but they can't right now. They can't force you not to pay another agent for their services provided in bringing a buyer to the closing.
Yeah.
They can't.
Right.
Yeah.
Kind of to piggyback off your initial question, Steve, just in reference to like something that Steve does often, it's seller concession is offered to the buyer to help them reduce their financing
Yeah.
costs. Is that allowed? Because that's to the buyer and not
Yeah.
the buyer.
Yeah. So it'll be to the buyer, and then the buyer can pay their agent. So that's kind of what they're saying is seller concession to the buyer will be closing cost credit of $5,000 and broker commission credit of, say, $22,000.
You can't put that in MLS.
Yeah. So I'm saying.
You can't put it in MLS, you can put it in a purchase and sale agreement.
So on the MLS, could you say seller is willing to, offer X amount of credit towards? No.
I don't think so, no.
That's to the
And there was
buyer.
I think it's the same thing. It's just another way of saying it, yeah. I don't think you can do that. I think that NAR won't allow it on an MLS listing. And eventually they're going to look at the listing and they're going to bar it. So, anything that's going to mention commission to a buyer's agent,
But it's not commission I'm talking about. Like 2-1 buy down, that's in reference to financing.
Right.
Like it's not a commission.
right.
So that's where my question comes from.
If it's interpreted as commission, they'll block it. I mean, at some point they're going to look at the semantics, and it becomes semantical at that point. But again, if it's on MLS listing, I mean, what's going to end up happening is the process is going to change. You're going to get a buyer's agent say, hey, do you guys give me splits? Yes, we do. Okay, I got people to bring to you.
This is so
But the thing is, 3-1 buy down, you mean, right? That is for a buyer, but on top of that, we pay buyer's commission anyway, right? That's 2.5%. So if you give 3-1 to a buyer himself,
Well,
you mean that they will decide whether to use that towards
No. 2-1 buy down that Steve offers, that goes directly to a financial institution
that's
to
right.
It's
help.
cut to the bank.
Yeah,
Yeah,
but
so like
that
that's not a
has nothing to
commission.
do to the agent.
What's that?
That has nothing to do with the agent.
No.
The buyer's
That's
agent.
why I feel like it should be allowed, and that's why I'm asking the question.
Yes.
There's a problem because it's being paid to the bank.
No, I agree. I think, again, this is all very much in flux. We're not going to know exactly how this is all going to play out really until the next few months. And how people are going to start to address it and what are going to be the ramifications of that. Now, remember this, that you have a decision by NAR, you have a decision by a federal court, you decide that you want to disregard all of it and start doing stuff the way you did it for a long time. That could bring an action against you at some point. And someone could say, look, they told you all of this and you still disregard it. Or the Department of Justice comes down, or the Federal Trade Commission comes down and starts to put restrictions on what can be done. And I think that's what they're more fearful of, is that the FTC or the Department of Justice comes in and says, we're considering this a monopoly, we're going to limit the fees that you can charge, and you're going to have to show, a buyer's agent is going to have to show that they've contributed contributed their efforts in order to justify their fee. And I think that's really what they're getting to. The seller's agent puts it on MLS, markets it, does all of these things. Some buyer's agents, as you well know, pick it up, bring a person, and then get a commission. They don't like that, and they've talked about that in the litigation. And so this was the original problem that buyer's agents had 20 years ago, is the seller's agent was saying, well, what are you doing? Well, I'm doing the same thing as another seller's agent who just brings the person. I didn't list it either. I'm not the listing agent. I'm the procuring agent, but I'm still a seller's agent. And so that argument kind of went away. But the DOJ has really kind of harped on that in terms of what is the agent actually doing to justify the commission. From the selling and from the listing agent, they know you've got an office, you've got a reputation, you're marketing it out there, you're spending money, time, and effort. Everybody else is what the DOJ is looking at. Any other contributing agent that's bringing someone in, that's who they're looking at. They're never going to change the listing agent and what they do. But I think, and again, I could be 100% wrong, but what I'm garnering from a lot of this is that that's where they're going to start coming in. They're starting with buyer's agents, and they'll be looking also at contributing agents. Now, if you go back to the same seller's agency where everybody's a seller's agent, there's no problem there. I mean, that's what we were. We were always seller's agents. And you were a listing agent or you were a procuring agent, but everybody was a seller's agent. Now, does that mean that you can't bring a buyer in and help them? Of course you can, and we always did. We helped as more facilitator for the buyer and listing agent for the seller, but we facilitated the transaction on behalf of both parties. We just weren't an agent for the buyer. But some people that couldn't get listings started out as buyer's agents because it was easier for them. They didn't have to have a big office. They didn't have to have much anything. All they had to do was have a group of people that wanted to use them to bring them to houses. And again, this was also at a time before the internet was big where you actually brought people to houses. Today, there isn't that much of it anymore. And this is another thing that the Department of Justice harped on, is that majority of the people today are already looking on the internet and making decisions of what they want to see before they even get to someone's, And you look at agencies now on a Saturday afternoon, I don't know about here, but I look at some of the agencies near me where that parking lot would have been full on a Saturday at 11 o'clock in the morning, and there isn't anyone there anymore because that's just the way it works today. You make appointments, you go, you see, that's it. Nobody's getting in a car, coming into an office, sitting down for an hour and looking at books. That hasn't happened. So yes, the industry will change, as the president of NAR says. The industry is changing. Where it goes, we really don't know. But just remember, the only two things that relate to the NAR litigation are no more listing of compensating commissions on MLS and buyer's agents. If you're a NAR member, buyer's agents have to have a written agreement. It isn't the law. It doesn't say that every buyer's agent has to do it, but that's a NAR requirement. Yep.
Just a question of opinion. I mean, what benefits does NAR really offer for current agents?
It had clout at one time to say that you were a NAR member. Again, when there were far less agents and an office was a NAR member. You were a member of your local Association of Realtors, Greater Boston Real Association, Mass Association of Realtors, whatever. That did carry clout at one time. Does it carry that same clout today? I don't think so. Agents are pretty much independent. At one time, you were an agent of an agency. Your email was the agency. Your telephone number was the agency. You had voicemail with the agency. You didn't give a cell phone number, and you didn't have your own email address. That's pretty much gone. Everybody has their own, everybody acts almost as an independent contractor today. So that does definitely change the value of a NAR membership. It has been a tremendous asset to realtors in the past. NAR has convinced the American public that they do need a realtor, that they need the help of a realtor. And they've done all those commercials and the millions of dollars they spent, and their lobbying efforts have been tremendous. The fact that the United States still allows a deduction for interest on the mortgage is pretty much because of NAR. It's about $850 billion a year that the federal government loses in tax revenue because of that deduction. So NAR has pushed that heavily. There's been a very great political benefit for NAR, and there's also been a benefit in terms of reputation. But some of that has been sullied, obviously, by this litigation. And NAR has to now pay $410 million over 4 years. So that's going to be very difficult for them. National Rifle Association has gone through the same thing, but different. National Rifle Association was one of the strongest lobbies in the entire world. And they were fooling around with their money, and then their president was found to be cheating around with the money. National Rifle Association is a shadow of what it once was. That hasn't been the case. There hasn't been any flouting of money or problems or things like that with NAR, but this litigation showed that they were weak in that area. And once you show weakness, that's when the Department of Justice and the FTC come in. And so I think things will change, as the NAR president says, but we won't know what those changes are. Again, if you're a listing agent, I wouldn't worry a bit. I don't think there's any limitation there. If you're a buyer's agent, things could change, definitely. And if people start to go to buyer's agents and say, I'm not paying you a percentage, I'm paying you X dollars, then you become facilitators and you get paid a set fee to help out. And they're right. Now this is going to cost buyers money, which before it didn't cost buyers money, unless you go with the argument that, well, it was all built into the purchase price. So, yeah.
I think that buyers are going to examine what they're paying much more, scrutinize it much more. Because in the past, it was like, well, the seller is paying your fee, so don't worry about it. So if you're selling an $800,000 condo, which around here is very common, at 2.5%, the guy, she's going to say, well, closing is going to have to cut me a check for $20,000.
Right.
They're going to say,
They're not gonna. Yeah, they're not gonna.
so it's going to have a huge effect on buyers.
It will. It definitely will. If you can't offer compensating commission. However, nobody's saying you can't. They're just saying you can't list it on MLS.
Yeah.
And so, but again, if that has to be part of a negotiation on the offer, yeah, it's going to be a little more difficult. Because what's a seller going to say? Why am I paying the commission? No, I'm not going to pay
Well,
it.
I think the net will be the same.
The net won't be the same for the seller if they don't have to pay a buyer's commission. But again, who are they going to get into the property?
Yeah, but I would think that the buyer would, if he's gonna have to pay the agent $20,000, they're gonna reduce their offer by $20,000.
Potentially, yes.
Yeah.
Potentially,
Probably
but
not in a competitive market. They're gonna have.
you're in a seller's market, so yeah. If it was a buyer's market or a middle market, yes.
Sellers are gonna make more. Buyers are gonna have a harder time making competitive offers. That's like, at the end of the day, that's
Yeah.
what's happening.
Yep.
Yeah, the first time home buyer is the one that really gets hurt.
Yes.
Yeah. I mean, let's put it this way. Buyers are going to start to flock to those places that are free. They're going to go to the Redfins and all of these places where the commissions are lower and the fees are lower and they've got all the online stuff. So you guys are going to have to compete more for the buyers.
What is the impact of these tech companies like Redfin, Zillow over these settlement or
I don't know, be honest with you. I can't speak as to them. You know, they were pariahs for a long time too in the market. Believe me, when buyers agents first started out, they were really pariahs. Yes.
Why do you think that, because of all the stuff coming out in the media, they're really getting the story wrong in a lot of cases, and NAR has been completely silent. They haven't come out, they haven't had an interview on the news or stuck up for agents or said anything. Is it because the court hasn't signed off yet and they're holding, or they don't plan on?
That's a good question, and I don't know why. I don't know why. And you're right. I mean, people, it's like my wife will always tell me, well, so-and-so, this happened. I said, well, no, that's not the law. Yes, it is. Well, no, it's not. Well, I saw it on TV. Well, I don't care. It's not the law, you know. I mean, I've been doing this for more than a few decades. No, it's not the law. But, you know, they always get it half right. And again, it's like the telephone, you know. By the time somebody gets to the story, it's been mutated 14 times.
But we pay for representation from NAR, and they've said nothing. They haven't come out and said anything, and I find that really disturbing.
I think they're embarrassed a little bit by it. You know, the fact that they have to pay $400 million judgment,
Right.
and somebody's going to ask them the question, well, why are you paying the judgment? Why do you think you owe this judgment? Did you cheat sellers? And what are you going to say to that? You know, so that's a hard one for them. You know, you could come out, and NAR could come out and say, look, you know, we've looked at what people want today, and we get it. This is what they want, so this is what we're going to do. But reality is they basically settled on a huge case that alleged that sellers were being cheated and that NAR NAR and other large realty companies were culprits. And the other companies paid too. They settled and paid too. So, you know, when you do that, it's hard to get up there, and if you've got somebody who's really going to ask you questions. But I think they could have gotten out there a little more,
Just
obviously.
to stand up for the realtors. I mean,
Yeah.
they're supposed to be our
Well, stand up for buyers agents.
Yeah.
Yeah. And say buyers agents provide tremendous value.
Right.
Now, I'll tell you, from the lending industry, as you know, and from the attorneys industry, closing agents industry, if buyers agents go away, we've got a lot more work.
Oh yeah.
we've got a lot more work to do. So it's not like this is going to be easy for us. Buyers agents over the years have helped us dramatically in bringing the buyers, explaining to buyers, holding the buyers' hands, all of those things. When they're gone, you know, the seller's agents can do so much, but again, having that buyer's agent has been extremely helpful to us in the closing industry and obviously in the lending industry as well.
I think there'll be another class action lawsuit. First-time home buyers are gonna sue saying, it's not fair, we don't have the money to pay for representation plus a down payment. And there's gonna be backlash, I think, somehow from them.
Yeah, again, nobody knows how this is going to work out. You know, if you look at places like Rhode Island where they've gone primarily to facilitators, I think that's something that we need to look at too, where you get out of the whole agency part of being a realtor, you know, being a fiduciary. There are some benefits to that. That's what NAR sold for a lot of years. But again, there's a lot of liability for that as well. And so if you have a groups of facilitators that can work together, then you don't have the term agent, and maybe we can work something differently where that can be facilitated in a better way in terms of compensation. We have to wait till the final decision comes down, see if Department of Justice and Federal Trade Commission have further commentary, see if the court agrees with the settlement, and once that happens, we'll know exactly kind of where we're at. But there are always going to be questions associated with this. It's not going to stop. And it's not the end of it either.
What are your recommendations to the agents moving forward?
I'd say right now, just don't put the you know, the contribution. Well, I mean, you probably still can, but be careful. You know, again, if I mean, they settled a you know, a $1.2 billion lawsuit because that's what they were doing. So to continue to do it and saying, well, it hasn't been decided yet, I don't know if that's the wisest idea. And so consequently, I would say that you got to start thinking about, I mean, today, yes, you got it out there, but start thinking of different ways that you're going to start showing people that you offer a you know, a contributing conversation. Yeah.
Just thinking out loud a little bit, but doesn't it feel like this might significantly devalue the importance of the MLS, period? Like, wouldn't it make sense for us all to go invest in like the best website possible that gets the most amount of exposure? Because then we can market these things however we like,
Yeah.
instead of being under the restrictions of NAR and restrictions of MLS.
Well, like the commentary said, it doesn't restrict you from your own agency's website of listing compensation.
Yeah, seems like it's just everything's going to move away from the MLS.
You know what it's like? If you ever had kids many years ago, you had PTA, Parent Teachers Association. And the PTA was this big national organization. They started charging like tremendous amounts of fees to local PTAs. Guess what happened? We had PTOs, professional teachers organizations, or professional parents. You didn't have PTAs anymore because they didn't want to be part of that and pay the fees and have to go with all of their rules. They developed their own independent ones by school. So this may be where we end up in terms of National Association of Realtors and local realtor boards. Yeah, this could be a defining moment for all of that. Is that good? Not necessarily. You don't want to have 17,000 islands, you know, because right now you've got one mainland and the islands are all within that mainland, and that mainland supports all the islands. But if they're all independent, there's no support.
Well, some commercial entity will enter and
Yeah, I think, you know, you might see everything morph.
yeah.
You might see everything morph. Again, nobody really knows what's going to happen yet. This is all so new. It just came down a month ago.
So
But
should buyer agents now already have the conversation with their client to say, this is what my fee is? Right now, you know, there's still, the other side is contributing money, but should we already be having that conversation with them saying, this is what you owe us? And, you know, we have to ask the others, or wait until July.
I think you really got to think about that really heavily.
I started actually saying that.
Did you?
Yeah.
Yeah, because I think it could turn a lot of people off. You know, it could turn a lot of people off. And this is what exactly happened at the beginning of buyer agency, is it turned a lot of people off to buyer's agents.
What I articulated.
There's still a
with my-
lawsuit in Massachusetts, correct?
What's that?
Similar to the NAR suit?
I'm not aware of it.
There is something.
Is there something? Yeah.
Yeah.
I'm not aware of that one. But, yeah, and
Don't talk about it yet, cause the court hasn't signed off, or?
I mean, I don't know that you need to get it. I think you gotta, as an organization, you gotta really come down with a you know, what your plan is.
Yeah.
How you wanna address it, what language you wanna use,
Right.
documents you wanna use, everything. What your buyer's agency agreement is going to look like. It doesn't have to be the NAR or MAR or whatever those agreements are. It could be your own,
Yeah.
you know, but how you want to address it. You know, it might be we're primarily looking for a contribution from the seller's agent, or a seller's you know, is going to pay the costs in the purchase and sale agreement, and then if not, you owe us X figure. But I mean, again, you really got to think about how you want to address that.
Right.
So, kind of segueing in a little bit, you have what I passed out to you guys, Unlocking the Secrets of Home Ownership. This will be what's called the Little Blue Book, and there's been a lot of effort put into this. And part of this is so you can sign your buyers to a contract. It's a gift that we're going to be giving to a buyer. It goes over everything. Part of the attraction to signing a contract with us too, Michael's contributing to, and that will be if if a buyer closes with a bank that Michael can do the closing for, there will be no charge to the buyer for legal fees. So he will represent them for nothing, as long as he's on
The buyer side of the representation. The only fee will be the fee charged that we obtain from the lender for doing the closing. But
So,
no buyer rep
as long as
fee.
he's doing the closing, you
Yep.
can offer legal services, right?
Yep.
For them to review contracts and
Yep.
for him to represent them in the transaction.
Individually in the
Which
transaction.
is phenomenal. That's great.
How
And
much
we'll,
would that,
Huh?
how much of a dollar monetary value?
1,000?
Yeah, we generally charge about $9.95 to represent a buyer in a transaction, a seller in a transaction. In this instance, you know, we're representing the lender. We generally get around $6.95 plus our title fee, title abstract fee. But there will be no additional fee for us representing the personal interest of the buyer in the
Which
transaction.
lender is that?
Any lenders.
He's on a number,
We're in a number of lists.
So bottom line is this, let's say he wasn't on the list. You would call the lender and ask them to put him on the list.
Yeah,
Oh,
and they almost always will. We're on all the big lists.
I have an open list, by the way.
Yeah,
so I can do it with my current
Yeah.
offer too, right?
Yeah.
Call to the lender.
Yeah.
Have you.
yeah. Say I
Yes.
want this guy to close. I want this guy, this group to close
Well, first
my
you check if
transaction.
he's on the list.
Yeah, just
Then
call
you-
me and I can tell you.
Then you ask if he can
Yeah.
be, if he can be put on the list.
Yeah,
So we're gonna save $6.95 in this.
you're going to save a
You're gonna save
fair
more
amount
than
of
that.
money. Yeah,
So representation varies from as little as what Michael's
Okay.
charging, but up to honestly 1,900.
Yeah.
So you're gonna save $1,000 and $1,900,
Yeah.
which is really great.
And that kind of gives you a marketing.
of course.
expen-
Yeah.
expense,
It gives us business.
So in your little blue book, there is a list of things that we're offering
Okay.
when they sign up exclusively with us. So when we say, you know, free legal representation, that's under the premise that we say that. Okay, and there's a bunch of other stuff in
For
there
sellers,
for buyers.
for buyers. How about sellers?
Turn this one off.
Yes.
This,
Thank you.
this package is